Yes, Mr.
My Lord, can I first of all make clear that I wasn't, in the submissions I made before, I wasn't suggesting, of course, that there was any illegitimate purpose in the claim. I was just simply referring to the consequences if the remedies that were sought were granted. Now, we've looked to see...
Yeah, it never occurred to me you were. But
no, well, I just wanted to make the point clear, because I was trying to remember exactly how it was. We have looked to see if there's any instance of the appellants having proposed to the court that they could make an alternative form of partial permission. We haven't found anything yet. In addition, I checked over the lunch break exactly how the grounds of appeal are put, and that isn't one of the grounds of appeal that permission could or should have been granted on in relation to some forms of relief, but not others. My Lord, turning to the question of what was known when, the Divisional Court spent some time in its judgment making findings of fact and concluding that the claimants were in a position to bring their claims from early November. It's paragraphs 140, 141, and then again they return to it 151, 152 of the judgment. Now, my Lord, we say, of course, that these are findings of fact. The Divisional Court was especially well placed to be able to make judgments about when the claim could have been brought forward on the basis of the claim as it was presented to the court. But there is a decisive point against the appellants on this issue. The appellants, in their skeleton, paragraph 31, claim that they did not have sufficient information until the pre-action protocol response letters on the 23rd of November. However, this was obviously a point that the Divisional Court was alive to, and it considered the timing of the PAP letters at paragraphs 146 to 148 and concluded that there was no good reason for the lateness of those letters being sent. And at paragraph 148, that the appellants, the claimants, had no more information when they sent those letters than they'd had at the first hearing before Lord Justice Zacaroli on the 11th of November, yet they still delayed sending the notifications. So they could have, if they needed the information that they received in response to those letters, which the court held they didn't, but if they did, then they should have obtained that information earlier by sending the PAP letters earlier. My Lord, in terms of what the appellants knew when, there is correspondence at the beginning of November. Just for your note, I'm going to take you to one letter very briefly, but there's a letter from British Gas on the 3rd of November. That's in the supplementary bundle 3, tab 50, pages in particular 707, 708. And I would invite you to consider paragraphs 9A, B, F, and G, which essentially...
Is this something you're not taking?
I'm not going to take, just for time purposes. I'm going to give you that reference. I'm going to take you to a second letter.
What's the reference again?
It's pages 707 to 8.
So that's
the supplementary bundle.
Supplemental bundle 3.
Tab 50.
Tab
50.
50. Pages
707 to 708.
And some paragraph references.
9A, B, F, and G. And I'm just going to take you to, as it were, counterpart letter from E.ON, which is at tab 53 of the supplementary bundle 3. That's tab 53 of the supplementary bundle 3. Page 717. This is a letter of the 4th of November. And perhaps I can just ask you to cast your eye through little a and little b under the heading Fair and Due Process.
Yeah.
And similarly, there's a heading state subsidy on the next page, and the complaints are similar. There's a passage in the middle of paragraph A, for example, beginning, for example, it would seem obvious that had financial support been offered to all participants in the SAR process, etc. Now, as Mr. Beale put it in his opening submissions 2 days ago, he described the nub of the case. The nub of the case, he said, was the failure to provide information to the participants about the subsidies. And that's what's been canvassed in these letters. In addition, in the...
Could my learned, while we're on that letter, my learned friend also refer the court to page 719, next steps.
Page 719.
Next steps, same letter.
What part of 719?
Where it says next steps.
Yes, I see, thank you. Yes? Want to say anything about those paragraphs, Mr. Hickman?
I'm just reading them. Well, my lord, this is just, I mean, obviously there's repeated requests for information at various times, but the point that the Divisional Court made was that it wasn't necessary for all of those questions to be answered in order for the claims to be brought forward. So we don't shy away from the fact there were numerous letters asking for information. A lot of the information that was sought, it was wholly irrelevant. It was to do with Ofgem's position on various things and so forth. My lord, in the proceedings before the Chancery Division, in which the appellants intervened, a substantial amount of information about the structure and about the subsidy was provided. That information was before, that evidence was before the Divisional Court. It is not before this court, but to give you a sense of what it contained and how far it went, can I ask you to turn to the skeleton argument of Scottish Power in the first supplementary bundle, page 370, tab 15. So, there was a very substantial witness statement from Mr. Cowlishaw's sixth witness statement, which was filed in those proceedings. There were exhibits. A lot of the sensitive financial information was redacted, but nonetheless, a lot of information was provided. And if you look, for example, at paragraph 7 of the Scottish Power skeleton, and this skeleton argument is dated the 10th of November, so it's the day before the hearing. Paragraph 7, I'm sorry that Lord Justice Zacaroli is reading this for the second time. You will see the way they summarise at paragraph 7. It's essentially the same point that was addressed before the Divisional Court that's being ventilated now before this court. And if you turn forward in the skeleton argument to page 385, there's a heading, the marketing process. That's the sale process. Paragraph 44, Scottish Power has significant concerns about the manner in which the business of the company was marketed. The key points are set out in Ward 1. You don't have that, but it was...
So where are you reading from now?
385, under the heading marketing process.
But which paragraph?
44, my lord.
Yeah, thank you.
Directly under the heading. And you can see reference there to Cowlishaw 6. And at 52 over the page...
I'm sure Mr. Perrett would want to remind you that it says the evidence is incomplete in a number of important respects.
Yes, but what did they need to know? What Mr. Bill was suggesting on Monday was that they didn't know that there was a state subsidy. It was absolutely clear from this point that they knew that. And that's the essential nub of it. They knew there was a substantial subsidy. They knew that the way this was structured was to provide comfort for their unhedged position over the winter period. Obviously, there's no figure on that because it would depend on energy prices. But that was the essential nub of it. And they said, well, we didn't know. No one told us there was going to be a big subsidy, or potentially a big subsidy, depending on which way energy prices move. And they clearly knew that. Paragraph 52, my lord, could I ask you just to cast your eye through paragraph 52?
Yep.
And then over the page, my lord, 387, page 387, under the heading, the deal with Octopus Energy, we rely on 55, 56 and 57. It's a lot to ask you to read, but the essential gist of it is they knew plenty and sufficient, the Divisional Court held, to plead a judicial review claim in the form advanced. And then the central point is paragraph 60. The government has not carried out a competitive, transparent and non-discriminatory process with other potential buyers to determine the amount of government support, if any, which may be necessary to acquire the company's business.
Is there any difference? This is a skeleton.
This is a skeleton argument.
Is there any difference in terms of counsel's responsibility in putting this in a skeleton as opposed to a skeleton?
My lord, I'm not sure that there is. And in any event, what you get from that skeleton is the facts and what they knew about the facts. And my point is simply that there was evidence, and ample evidence, on which the Divisional Court could reach its conclusion that the claimants had enough to plead their cases and bring their cases quickly to the administrative court. And the other answer that I have to my Lord's question is that it is incongruous, to say the least, that the appellants considered they had sufficient material to intervene in the proceedings before my Lord and effectively asked my Lord to grant interim relief. My Lord said that was effectively, in my Lord's judgment, effectively what they were seeking to do. But they say they didn't have enough information to make the same application to the administrative court. In my submission, there was ample evidence in which the Divisional Court had reached the findings that it did. My Lord, in terms of prejudice, I've already made the submission by reference to authority that it's not necessary to show a causal connection between the relief and prejudice as such. But in any event, there was prejudice to third parties, to my clients, to Octopus, to others, because they were disempowered. They were aware that the appellants were threatening judicial review proceedings, and they were aware of the consequences that the appellant said were going to follow if those proceedings were successful. But there was nothing they could do until proceedings were issued. And this is one of the reasons why it's so important to issue promptly where there will be an effect on third parties, because the third party can't do anything to advance those proceedings until the proceedings are issued.
But what can they do anything to advance the proceedings once they are issued?
Once they are issued, as in fact we did, the JEAs did, then we immediately applied for an expedited hearing before the effective date. So once proceedings are issued, if no interim relief application is made, the interested party can apply for expedition. But there's nothing they can do until proceedings are issued. All they just simply bystand. And that opportunity was lost. As soon as proceedings were issued, that application was made. Regrettably, given the timing, the court considered there wasn't going to be time to get the case on. But valuable time was lost. And it may have been possible to get the case heard before the effective date had the JEAs and the government been able to make that application sooner. We do say the failure to apply for interim relief is relevant. I've taken you to an authority on that. If a claimant knows they are not going to apply for interim relief, and therefore the court is not going to suspend the coming into effect of the decision, that makes the case for them seeking to get a hearing on before all of the consequences could occur, all the more important, and allowing interested parties to apply for an expedited hearing that could be heard before all the potential consequences could occur, all the more important. And if the claimants knew they weren't going to apply for interim relief to the administrative court, that made it all the more important that they applied promptly, so that an effort could be made to try and determine a claim promptly before the effective date or the effective time. Now they say, oh well, we weren't prepared to give an undertaking in damages. Well, in my submission, that's not a good answer in principle. But in any case, and this is a point made by my Lord Justice Zacaroli in his judgment, the administrative court has a discretion whether to accept an undertaking in damages, whether to require an undertaking in damages, how much. And that is a very broad discretion. And the authority for that is the Belize Alliance case, 2003, One Weekly Law Reports, 2839, paragraph 39. I'm afraid it's not in the bundles. I've given it to my learned friends and said I might refer you to it, and I'll ask for it to be put into the additional authorities bundle. Finally, the points raised in the grounds of appeal about Mr. Justice Swift. If my Lords read the judgment of Mr. Justice Swift and also what he said in the transcript after he gave his judgment, and that's at Supplementary Bundle Supplementary Bundle 2, tab 24, page 522, at page 528, paragraph 19, he says that I can see delay will remain a live issue at the hearing. That will no doubt be a rolled up hearing, and delay may be relevant to whether the court ultimately grants permission for judicial review, not just remedy. It may be relevant to the question of relief as well. I say nothing on either of those matters. So there's simply no basis for suggesting that anything the Divisional Court did was inconsistent with anything that had previously been decided by Mr. Justice Swift. My Lords, turning to the TCA, we say that the Divisional Court was correct that the reliance on the TCA can only, in any event, affect the claim insofar as it relates to recovery. So it doesn't affect the court's decision to refuse permission in relation to the pure public law claims that were brought, first of all, and in relation to the subsidy claim that raised...
Yeah, but it is the latter we're primarily concerned with.
It is, but we mustn't lose sight of the fact that it was in relation to both. My Lord, could I ask you to turn up the TCA? This is an authorities bundle 3, authorities bundle 8, of course, 3684. Sorry, 3695. And in particular, we need to look at 373, Article 373. Now, we say Article 373, first of all, has to be read in the following context. It has to be read in the context of the fact that the UK at the time has no system of subsidy control. And indeed, that is recognised in the second footnote to 373, which is, unfortunately, all the footnotes seem to be footnote 1 in this printout. I'm not sure they are in the official version, but in any event, it's at page 3702. It's actually noted, the parties note, that the United Kingdom will implement a new system of subsidy control subsequent to the entry into force of this agreement. And the second...
what's that a note to?
It's a note to 3737.
Well, I understand that, but let's see what the substance of that is.
It's basically, there's something called the Partnership Council, which meets once a year and has representatives of both the UK and the EU, and that does various things like consider the implementation of the TCA, and it can it can actually make amendments to the TCA in various respects where allowed. And
yes.
Here it's saying, there can be consideration of similar forms of relief to recovery by the Partnership Council.
But is it the effect of the TCA, just read it by itself, that pending a new system of subsidy control, but more specifically the introduction of the right of recovery in the previous footnote, referred to in the previous footnote, there would have to be a right of recovery?
Well, we haven't taken a position on that issue. I go halfway there in my submissions, as do Octopus, I think, in saying that effectively what 7373 is doing is it's a structural requirement. It's requiring that in general a remedy of recovery is put in place. 3737, which we just looked at, provides a mechanism for putting in place something that's not recovery but that does effectively the same thing. But 373 in general is a structural requirement. It's not creating a specific right that an individual in a claim such as this can rely on and say we have a right to bring a claim within a specific time limit and have a remedy at the end of it. And, my Lord, just to close off the point I was making, the context of 373 is, first of all, the absence of a subsidy control regime in the UK at the time that the TCA was entered into. And secondly, the obvious point that there was no remedy of recovery in the UK at that point. And that's obviously what 373 is in general directed at. So we say that 373 imposes an obligation to include recovery as part of the remedial toolkit in the UK.
Sorry, say it again. In what's the availability? Just say that sentence again.
373 imposes an obligation on the UK
Yes.
to include recovery
I see,
as
yes,
part of the
obviously,
remedial
yes.
toolkit in the UK. And if you look back to 372, you can see that this article is dealing, in point 1, with an obligation on the parties to ensure that certain rights and obligations, remedies, are available in the courts of that country. And as was pointed out, I think, in submissions on Monday, in little c, it says, if and to the extent that those remedies are available under the respective laws on the date into force of this agreement. So it's a sort of you can't go backwards clause. It's not imposing any new requirements. But that, of course, is subject to 373, which follows, which specifically relates to recovery. And it relates to recovery because there isn't a recovery, there wasn't a recovery in the UK at the time. And the first footnote to 373 is also relevant because it makes absolutely clear for the United Kingdom this article requires a new remedy of recovery which would be available at the end of a successful judicial review in accordance with the standard of review under national law commenced within a specified time period. Such review is not expanded in any other way. So it's a structural requirement that requires, in general, a remedy of recovery.
What do you mean by in general? Why are you
Well,
emphasising?
it's requiring the UK to have in place a remedy. What it's not doing is providing, as it were, a right for somebody to say, well, we've made an application within a specified time, a relevant time, and therefore, because we've done so, at the end we have to be entitled to a remedy for recovery, because that would be to create a right out of Article 373. And we've seen, you were taken to Article 5, which says that such, it's not the purpose of...
I'm being slow, I'm not understanding your point. As from the moment that this comes into force,
Yes.
UK has to have a remedy of recovery.
Yes.
Why shouldn't that be subject to the specified time limit provisions?
Well, in a sense it is, but it's a general requirement. It doesn't necessarily give an individual a cause of action. If you remind yourself of Article 5, that nothing in the agreement shall be construed as conferring rights on persons other than those created between the parties. So that's the point, my lord.
I'm being very slow. My lords have probably understood you, but I...
Is all you're saying, it doesn't create a right, it creates a right to the remedy insofar as UK domestic law principles will allow it, for example, discretionary principles, etc.
Yes, my lord. And you heard the submissions yesterday about Lipton. I mean, effectively, what's being said here is that the provisions in the Senior Courts Act that permit the administrative courts to refuse permission on grounds of undue delay are overridden by the TCA in relation where you've got a claim for recovery. And we say that's not right, because that would be to give the TCA a direct right that overrides the procedures of judicial review. Sorry, my lord, I am having to make these submissions quicker than I...
Well, that's your own choice.
It is my own choice, my lord. But,
Because this...
my lords, we also make the point in our skeleton argument, and this may be sufficient for my purposes, and this is at 36 to 41, that even under EU law, recovery is not an automatic remedy where a subsidy is found to be unlawful. So there are cases where the Commission has refused to order recovery by reference to general principles of EU law. And we refer, for example, to decision of 2006 on the French tax code, which is in Authorities Bundle 6 at tab 174. Now, the way Mr. Peretz dealt with those cases, he said, oh, well, those cases are all cases where there's been a very extensive period of delay and recovery is refused where there's several years have gone by. But there's nothing in those cases and the principles articulated in those cases which limits them to very long periods of delay. So the principle is that recovery is not necessarily an automatic remedy, even where a subsidy is found to be unlawful. If that's the case, then the Divisional Court would be entitled to refuse, if it wanted to, it would have been entitled to refuse relief on grounds of undue delay. It would have been able to refuse a remedy on grounds of undue delay. Now, it didn't do that. It refused permission. But in my submission, it can't be the case that if a case is not, at the end of the day, going to succeed in attaining any remedy because it's been brought late, that the court should have to hear the case before denying the remedy. So the fact that you can deny the remedy for undue delay tells you that you're entitled to refuse permission on grounds of undue delay. My Lord, we make those points in our skeleton argument 36 to 41. So we say, essentially summing up those points on the TCA, we say, firstly, the Divisional Court was right to say that they have no wider impact than in relation to any claim for recovery. So they can't have any effect.
Yeah, well, you've made that point, and that is the whole point of the case on delay. But there's a recovery claim here, not just a quashing claim. But it's as if you're saying as if this is really only a minor point, but it is the main point.
Well,
certainly as regards 373.
yeah, well, my lord.
Anyway, sorry, keep going.
Secondly, we say that just because T373 has this time limit in it, it doesn't mean that an individual is entitled to say that it has a right under domestic law now to bring a claim within that time limit. And a right.
It's not just a time limit, it's a time limit with an associated procedure about the acquisition of information.
Yes. And there's no doubt that the UK has committed to putting in place a recovery remedy that embodies those procedural rules or has done so. But it's a much bigger step to say that somehow that trumps the rights under, or the power under the Senior Courts Act, section 31(6), which
It doesn't trump them. It simply would be a relevant and, in certain circumstances, a decisive factor in the exercise of the discretion granted by 31(1)(a),
yes,
necessary to extend the time limits. Or in the first, it really actually doesn't affect 31(1)(a), which simply says promptly. If it bites at all, it's on the rule, which says in any event within 3 months. But even that's extendable.
my lord.
So there will be no inconsistency between UK law, would there, and the procedures, the provisions of the TCA?
Well, there would be an inconsistency in the sense that if a court has power to refuse permission or relief on grounds of undue delay, what the appellant says, well, they can't if it's a claim for recovery.
Better way of putting it, there may be no undue delay because we were operating the procedures under the TCA.
That, in my respectful submission, is a slightly different point. I mean, it is relevant. I accept that it's relevant to the consideration of undue delay that there is this provision, and the Divisional Court considered it. I mean, no one suggests that the Divisional Court did not consider this matter. It was squarely taken before the Divisional Court. The Divisional Court found that it didn't affect the exercise of its discretion.
Sorry, I've just had a stationary malfunction. Do carry on. I mean, you're
My lord,
you've made your peace with Mr. Panic, have you?
well, no, those are
I see.
the points that I wish to make, my lord.
Very well. Well, Mr. Panic is itching to get to his feet. Sorry, I said Mr. Panic. I should have said Lord Panic, of course.
On behalf of Oxford's 5th and 6th interested parties, I do gratefully adopt the submissions that have been made by Mr. Koppel and by Mr. Hickman. And I've got just a few points to add, if I may. First, can I address the meaning and application of section 29 of the European Union Future Relationship Act 2020?
Yes.
And you will just have that at Authorities Volume 8, tab 92, page 3669. And the Lord Vice President said early on in this case, this is a very unusual statutory provision because what it contains, see the heading, is a general implementation of an international agreement. And of course that international agreement only takes effect itself on the international plane, and that's recognised by Article 5.1 of the international agreement. It confers no rights, no obligations on anybody else other than the state parties. And it's more complicated because, as Mr. Coppell showed the court, the Supreme Court in Lipton, I don't ask you to go back to it, but it was Additional Authorities number 3, page 70. That is Lord Sales and Lady Rose, with the agreement of Lady Simler. They rejected Lord Justice Green's analysis that Section 29 has generally transposed the TCA into domestic law. That was paragraph 74 to 79 of Lipton. And their lordship and their ladyship said Section 29 does not confer, quote, such an intrusive and automatic effect in our law. What the Supreme Court did not tell us is what effect Section 29 does have in domestic law, and plainly Parliament intended in Section 29(1) that it would have effect, not least because it's an international agreement to which this country is party. We have obligations.
Yes, I think that observation in Lipton, the key phrase is such an intrusive. It was objecting to what it perceived as being the implications of Lord Justice Green's formulation in a case of the kind before it. It wasn't saying it couldn't implement.
No, but what they didn't tell us is what effect it does.
Yeah.
And Mr. Coppell's answer to that conundrum was that under Section 29, the subsidy control principles, we're not dealing with anything else here, but the subsidy control principles do have effect as public law principles. That was his suggestion. And your lordships then asked for assistance on what these public law principles are. And my answer to that question is that illumination is provided as to what we on this side mean by public law principles if we go to the Subsidy Control Act 2022. I appreciate, of course, it was enacted later, but just to identify what is meant by public law principles. Your lordships have the 2022 Act, volume 8, tab 94, and it's page 3710. And section 12 tells us, under the heading Application of the Subsidy Control Principles, this: 1, a public authority, A, must consider the subsidy control principles before deciding to give a subsidy, and B, must not give the subsidy unless it is of the view that the subsidy is consistent with those principles. And that's what I mean by public law principles. There is a standard, a relevant standard. It is for the relevant public authority to consider that standard and form a view on its application to the relevant facts when taking a decision.
Yeah.
That's a public law principle, and it's in standard form. And what is also standard form is what one then has in this same Act, a review mechanism. Once the decision is taken, it is subject to a review, and in this Act, the review is in section 70, which is on page 3734, and it's a review by the CAT, and section 70 subsection 5 tells us that the CAT, the tribunal, applies the same principles as would be applied on a judicial review. And there's nothing unusual about any of that.
Effectively, you're saying that the drafters of the 2022 Act understood what the obligations of the TCA were and how they were meant to work, and although we're not bound by that, we should give great weight to that, and indeed it would be undesirable if the position were different before and after the Act came into force.
Well, it would be extraordinary, in my respectful submission.
Undesirable.
Yes, it will be undesirable. But it goes further, your Lordship's absolutely right, but it goes further than that, because if we go back to the 2020 Act, which was tab 92, on page 3669, we see...
You said the 2020 Act?
2020, yes. 2020 Act is tab 92.
Sorry.
And we look again at section 29.
Yeah.
We see that there is a section 29.2 which envisages that there will be further legislation. And section 29.2 tells us that subsection 1 is subject to any equivalent or other provision, Roman 1, which, whether before, on, or after the relevant day, is made by or under this Act or any other enactment or otherwise forms part of domestic law, and Roman 2, which is for the purposes of, or has the effect of, implementing to any extent the TCA. So Parliament was well aware that to put it at its lowest, there could well be further legislation to implement the TCA. And none of this is very surprising once one considers the chronology. The UK left the EU on the 21st of January 2020. But, your Lordships will recall, there was then a transitional period which ended on the 31st of December 2020. The TCA was agreed 7 days earlier. It went right to the wire, and it was agreed on the 24th of December 2020. And it came into force on the 1st of May 2021. The 2020 Act itself received royal assent on the 31st of December 2020. And it came into force on the same day as the TCA came into force, which was the 1st of May 2021. So it was absolutely plain that more detailed legislation would be required to implement the TCA, and that's exactly what happened. Your Lordship put to me, and I respectfully agree, that it would be surprising not to interpret in those circumstances the 2020 Act with regard to the 2022 Act. But in my submission it goes further than that, because there is a principle of statutory interpretation which recognises that earlier legislation can be interpreted consistently with later legislation on the same subject, to the extent that the earlier legislation is ambiguous. And that's the principle in the Hong Kong case, the Hang Seng Bank case, which your Lordships have in the supplementary authorities. Could your Lordships please turn that up? The bundle of supplementary authorities. And behind tab 1, we have the Privy Council advice in Hang Seng Bank. And Lord Bridge is speaking for the board, and the relevant principle, I won't trouble with all of the details of tax case. And if your Lordships would go in that supplementary bundle, tab 1 starts on page 3. If your Lordships would go to page 20 of the bundle, it's page 323 of the report, your lordships will see at the bottom of that page, by letter H, the sentence, "To this, council responded that the legislature cannot, by an amendment to existing legislation, which proceeds upon a mistaken belief as to the effect of a provision in the original enactment, alter the meaning of that provision." This is no doubt perfectly correct if the meaning of the original provision is clear and unambiguous, but it is otherwise if there's any ambiguity in the original provision. The principle is stated by Lord Sterndale, Master of the Rolls, in Cape Brandy. "I think," he said, "it is clearly established that subsequent legislation on the same subject may be looked to in order to see what is the proper construction to be put upon an earlier act, where that earlier act is ambiguous. I quite agree that subsequent legislation, if it proceeded upon an erroneous construction of previous legislation, cannot alter that previous legislation, but if there be any ambiguity in the earlier legislation, then the subsequent legislation may fix the proper interpretation to be put upon the earlier." And Lord Bridge adds that this statement has been referred to with approval on a number of occasions by their Lordship's House, and indeed more recently by the Supreme Court. So that's the submission. There can be no doubt that whatever else might be said about the 2020 Act, it is at the very least ambiguous.
Yes. Could you not now, but just afterwards, give us the reference to the more recent endorsement in the Supreme Court? Simply for form's sake.
We have those, and we will give them to your Lordship. So that's my first submission. My second submission is, in any event, the TCA does not require this country to provide, in this context, other than our standard provisions for dealing with review of a decision. And we see that in Article 272 of the TCA.
372, I think.
372. But before I go to that, can I just emphasise that there are two distinct questions which arise under the TCA. The first question is, what are the relevant obligations of the United Kingdom under the TCA? What does the TCA require of this country in terms of substance, relating to substance? But the second question with which I am concerned is the question of what does the TCA say about the powers of courts or tribunals which hear a complaint that the Secretary of State or other public authority has failed to comply with those substantive obligations. They're distinct questions. And the second question is addressed in Article 372. And if we go back to it, it's Volume 8 of the Authorities, Tab 93, and we find it on page 3697. We see that Article 372.1 requires each party to ensure, in accordance with its general and constitutional laws and procedures, that its courts or tribunals are competent to review subsidy decisions. Now, I make it quite clear, my case is not based on the word review. I don't say that means judicial. No. That's not my case, and on that I agree with the note produced by the appellants at 11:06 last night, past my bedtime.
I don't think it's reached us at all, but
I'm sorry, Lord?
It hasn't reached us at all.
Oh, right.
But I can guess what it says.
Right. But all that matters for my purposes, I'm not suggesting that review means judicial review. It means a process for reviewing a decision. What matters is 372.3, And what that says is without prejudice the obligations to maintain or where necessary create competencies, remedies and rights of intervention. Nothing in this article requires either party to create rights of action, remedies, procedures, or, and these are the relevant words, widen the scope or grounds of review of decisions of their respective public authorities beyond those existing under its law on the date of entry into force of this agreement. So the TCA imposes no obligation on this country to expand the scope of judicial review. And none of
And we
that
can,
is
I think, be
surprising.
confident that this didn't come into the article by accident or
No,
formulaically.
one would expect in an agreement of this sort, which is part of the negotiation, I won't add any adjectives to that, but part of the negotiation for exit from the EU, careful consideration was given to what exactly was being imposed on the United Kingdom. And indeed I would go further, because even in EU law, which, as I intervened yesterday to emphasise, is not something that is applicable under this agreement, but even in EU law, your lordships have seen an authority which shows that the English approach to judicial review is consistent with the obligations in EU law. Perhaps we should just very briefly go back to that. Mr. Cockle took you to the Friends of the Earth case in the Supreme Court, and it's in the supplemental bundle, and it's at volume, so it's at tab 2 of the supplemental bundle of authorities. And if your lordships please in that would go to page 62 of the bundle, it's page 230 of the report, and this is the judgment of Lord Hodge and Lord Sales speaking for the Supreme Court. And at paragraph 145, they refer to environmental directives. However, as the Court of Appeal observed, the type of complex assessment required in compiling an environmental report for purposes of environmental assessment is an area where domestic public law principles have the same effect as the parallel requirements of EU law. The Advocate General stated in the Upjohn case, I quote, "The court, that's the European Court, has always taken the view that when an authority is required in the exercise of its functions to undertake complex assessments, a limited judicial review of the actions which that authority alone is entitled to perform must be exercised, since otherwise that authority's freedom of action would be definitively paralysed." So nothing surprising about Article 372(3). On the contrary.
Yeah, and in passing, an example of what must be, I suspect, hundreds of examples of the European Court using the phrase judicial review in the general sense.
Yes.
Yeah. But that's not your main point, I
No,
agree.
that's not the point. Yeah. So if so far your lordships are with me, Mr. Coppell and I do maintain that it is not the task, with the greatest of respect, either of this court or of the Divisional Court itself to decide whether there has been compliance with the subsidy principles. The task of the domestic courts is a review function, review in the sense of judicial review. And the appellants must show that the Secretary of State's judgment in this case as to the application of the criteria is either unreasonable in the public law sense or there is some other public law error. It's not good enough to say we're inviting the court to form its own assessment by reference to the subsidy principles. An alternative, which was advanced by Mr. Beale, was that instead of applying a Wednesbury approach, perhaps the court should apply a test of proportionality. And I respectfully suggest, first of all, that my friend Mr. Coppell is right. There's no basis for proportionality assessment by the court here. It's a standard judicial review. This is not a human rights context or any other context which justifies the application of a principle of proportionality. But secondly, even if the test were proportionality, we respectfully submit that it's most unlikely to lead to a different result in the circumstances of this case or any case like it. And the reason for that is that when the court applies a proportionality test to review an assessment made by a decision maker, that is not a merits assessment. And the court recognises a margin of discretion for the decision maker, the width of which depends on the context. And that is so even in a context concerned with human rights. A fortiori this case, where no human rights are involved. And there are many cases which make this point about margins of discretion depending upon the context. A useful example is the Lord Carlisle case, which is at Authorities Volume 2 at tab 26. And this was a case about Mrs. Rajavi, who still is, an Iranian opposition politician living in exile in Paris. And she wants to come here to talk to supporters and potential supporters. And the Home Secretary of the day refused to grant her permission to enter this country. And that was the challenge. And there are two important statements of principle. One by Lord Sumption, and if we could please pick this up, it's page 966, it starts. And Lord Sumption at paragraph 31, which is at 990 of the bundle. And Lord Sumption says at paragraph 31, none of this means that in human rights cases, a court of review is entitled to substitute its own decision for that of the constitutional decision maker. However intense or exacting the standard of review in cases where convention rights are engaged, it stops short of transferring the effective decision-making power to the courts. And there's a citation from the speech of Lord Bingham in Corner House. Nor, as a general rule, does the Strasbourg Court require that administrative decisions should be subject to appeal on the merits, etc., etc. And another passage in Lord Sumption's...
That's not quite the point we're on here, is it?
Well, I am making the point that even a test of proportionality in the context of human rights is not a merits review. But it's,
I see. No, I was thinking more about the substitution of decision.
No, that I'm coming on to.
Okay. Anyway, so carry on.
And the other statement by Lord Sumption, which does address the point your Lordship is mentioning, is at the end of paragraph 33, which is in the law report, page 972. Your Lordships could turn to that. This is still Lord Sumption, and it's at B, where he says a very similar principle has been applied for many years to the review of commission decisions in Luxembourg. It's essentially the same point as Lord Reid made in Bank Mellet, when he observed that even in the context of the enforcement of convention rights, the relevant decision may be based on an evaluation of complex facts or consideration, for example, of economic or social policy or national security, which are contestable and may be controversial. In such situations, the court has to allow room for the exercise of judgment by the executive and legislative branches of government, which bear democratic responsibility for these decisions. The making of government and legislative policy cannot be turned into a judicial process. And that leads on to what Lord Neuberger said, endorsing an approach similar to what was said by Lord Sumption. If we pick up in the judgment of Lord Neuberger at Law Report page 984, paragraph 67, he says, having said that, it remains the case that when human rights are adversely affected by an executive decision, the court must form its own view on the proportionality of the decision. And I accept that in a proportionality case, or what is sometimes referred to as the balancing exercise involved in the decision. And there's some authority cited. As Lord Reid made clear, while proportionality is ultimately a matter for the court, it does not entitle domestic courts simply to substitute their own assessment for that of the decision maker. The degree of restraint practiced by domestic courts in applying the principle of proportionality and the extent to which they will respect the judgment of the primary decision maker will depend on the context and will in part reflect national traditions and institutional culture. And Lord Neuberger develops that point and the next paragraph, 68, accordingly, even whereas here the relevant decision maker has carried out the balancing exercise, has not made any errors of primary fact or principle, has not reached an irrational conclusion, so the only issue is proportionality, the court cannot simply frank the decision. It must give the decision appropriate weight, and that weight may be decisive. The weight to be given to the decision must depend on the type of decision involved and the reasons for it. There is a spectrum of types of decision, ranging from those based on factors on which judges have the evidence, the experience, the knowledge, and the institutional legitimacy to be able to form their own view with confidence, to those based on factors in respect of which judges cannot claim any such competence, and where only exceptional circumstances would justify judicial interference in the absence of errors of fact, misunderstandings, failure to take into account relevant material, or taking into account irrelevant material, or irrationality. And Lord Clark agreed with Lord Neuberger.
Just pausing there, though that does make clear, I'm not sure how much this matters, it just avoids us getting confused, that in a case where the decision is for the court, the way you respect the institutional expertise of the primary decision maker or the first decision maker is not as such by, as it were, allowing them a margin of appreciation or something like that. It is more you giving weight to their decision in your decision.
Precisely.
It's only a tiny distinction, but I think it's a real
It's an
one.
important distinction, and the weight that you give to their decision, this is the point, very much depends upon the context. I do submit that this is a context in which very considerable weight would be given if this were a proportionality analysis. I'm assuming...
This is all your secondary case, because you're saying it isn't a proportionality analysis in the
Even
first
if my
place.
friend Mr. Bealey's right, and there's some proportionality analysis, and the court itself is asking what is a proportionate decision, this is a context where the court would give very, very considerable weight to the judgment of the Secretary of State as decision maker, essentially for the reasons that Mr. Cockle has already developed. This is a decision based on economic analysis, and it's a decision based on expert advice, and it's a decision in circumstances of an energy crisis. where decisions were being taken in the public interest to protect energy supply to 1.5 million customers. And I do, with the greatest of respect, submit that applying Lord Neuberger's criteria, the Secretary of State is far, far better placed to make that assessment than this court. That's the submission. And it's not just, the argument for the appellants faces another hurdle, because it's not just that the reviewing court, even if it were applying a test of proportionality, which it should not be, confers great weight on the decision of the primary decision maker, the Secretary of State. This is a case where the appellants are inviting this court on an appeal to overturn the assessment that has been made by the lower court. And your lordships have seen, your lordships are very, very familiar with all of the authorities, consistent authorities, which establish that an appeal court will be very, very slow to overturn a factual evaluation by the lower court, whether or not that lower court heard oral evidence. And I just want to draw attention to one other authority on that point, because it's the Supreme Court authority, and it's the Carlisle case, which is at volume 2, tab 27, at page 1037.
The other Carlisle case.
Volume 2 of the authorities, tab 27, page 1037, and it's Lord Hodge speaking for the Supreme Court. And if we could pick it up, please, at page 99 of the report, it's paragraph 20, where Lord Hodge confesses that if he were deciding the matter at first instance, he might have shared the view of the second division, which had overturned the first court. But then he says at 21, deciding the case as if at first instance is not the task assigned to this court. And he mentions the authorities, and he sums up the position at paragraph 22 over the page. The rationale of the legal requirement of appellate restraint on issues of fact is not just the advantages which the first instance judge has in assessing credibility of witnesses. It is the first instance judge who is assigned the task of determining the facts, not the appeal court. The reopening of questions of fact for redetermination on appeal would expose parties to great cost and divert judicial resources, that's this case, for what would often be negligible benefit in terms of factual accuracy. It is likely that the judge who's heard the evidence over an extended period will have a greater familiarity with the evidence, a deeper insight into reaching conclusions of fact than an appeal court whose perception may be narrowed or even distorted by the focused challenge to particular parts of the evidence. And the Divisional Court emphasised, it was paragraph 20 of its judgment, just how much material it had received. And your lordships, I say with great respect to my learned friends for the appellants, are in danger of being misled by the citation of extracts from particular documents which they wish to emphasise.
Can I, sorry to interrupt,
Of course.
just as you've gone on to the findings of fact and review, can I just ask you about Article 3672, which had a rather hard-edged aspect to it, which is not to have any unlimited guarantees. What do you say the standard of review for something like that would be?
Well, I say it's the same. I say the Secretary of State, see Section 12, must comply with that.
Yeah.
But it involves an evaluative judgment on the facts of the particular case. Has that occurred or has it not? Assuming that 367 is applicable in this case, and that's what he's done. And his judgment is not to be overturned, in my submission, on the basis that your lordships are being asked to say that there is a breach of that provision. It's his judgment, and it's not a judgment on the material that's being presented, which admits of a public law error. That's my submission.
I think it isn't being objective in this case, that there's a problem with that. Take another case where something that the Secretary of State did either was or wasn't a guarantee, and that's a question of law. Then that could be characterised as an error of law.
Yes, if there's an error of law, the Secretary of State has simply misunderstood the meaning of a particular provision, but that would be standard judicial review.
Yeah.
It's no different in my submission. But where the complaint is about the evaluative judgment based on the facts of the particular case, then a judicial review does not lie, other than if it's perverse or he's failed to have regard to some relevant consideration. The facts has been covered extensively by both of my friends, but I just want to emphasise one matter, if I may, and that is that these appellants decided that they would not bid in phase 2 for commercial reasons of their own. And Mr. Coppell rightly emphasised, that there is a paragraph in the judgment relating to E.ON, which so states. It sets out, paragraph 39 of the judgment, that E.ON withdrew from the sales process, attributing this to a combination of factors. And Lazard's then said that 2 of them, which are the ones they're now complaining about, could have been mitigated. The response, this is what the Divisional Court say at 39, we observe that this response expressed a positive anticipation there would be a mitigation mechanism for volatility, the absence of a hedge, which realistically could only have been understood as some form of government support addressing these issues. And no other credible interpretation was suggested to us. There was no response from E.ON, who, according to Mr. Davis, did not even discuss the anticipated mitigation mechanism because it had withdrawn from the process. So they were not interested in going ahead. Simple. British Gas is dealt with in the judgment at paragraph 72, and 72 begins, as to British Gas, and can I just remind your lordships of some of the findings. 72 Roman 3, in May 2022, in the context of a communication on another subject, Mr. O'Shea, British Gas, informed the Secretary of State that British Gas's interest was in taking only some of the customers, which would have involved a split book solution. They returned to that at Roman 5. The meeting between British Gas and the Secretary of State took place on the 9th of June. At that meeting, handwritten notes taken by Ms. Walker at B's record BGT's position as being, we don't want to buy bulb, could take some customers, 500,000 maximum. A response to the same effect as the 15th of May communication quoted at 3 above. The Secretary of State indicated that selling it as a job lot, that's the whole book, would be the preferred approach. And there's other notes to the same effect. Then Romans 6, we are satisfied, this is the finding, these notes captured the essence of Mr. O'Shea's position as communicated, which is also consistent with internal Bay's email sent after the meeting. We've had confirmation that British Gas will not bid, but would be prepared to take a share of the customer book if there are no other bidders, and that BGT will not bid. We, that's the Divisional Court, can see no credible reason why Bayes, which was clearly concerned by the implications of British Gas dropping out, should have formed a negative view of their intentions, unless that was the outlook that British Gas objectively conveyed to them. It's noteworthy that Lazard was asked to contact British Gas to see if they could be persuaded to re-enter the process, reflecting a perception on the selling side that they had disengaged and a desire to reverse that state of affairs. If, as British Gas stated, British Gas did not intend to leave that impression, that was nonetheless the impression they left. Then Romans 7, at the end, British Gas's communications are consistent in their assertion of a readiness only to take some customers. Then at Roman 14, I'm not reading it all, I'm reading the relevant bits, Roman 14, British Gas did not in the period after 10th of June indicate any willingness to submit a further offer for Bulb's entire book, although again it raised the option of splitting the book. And also at 198, at the end of 198, the Divisional Court say that the circumstances are such that Lazard, the JAs and the Secretary of State were entitled to and did conclude that British Gas was not interested in a whole book acquisition. And this is all in the context, as the judgment states, that the Secretary of State was advised and accepted the advice that a whole book sale of Bulb's assets was preferable to a sale of part of the assets to different companies for various perfectly sensible reasons. I won't read it, but it's paragraphs 90, 91 and 120 Roman 5. So that's the reality of this case. And again, with the greatest of respect, my friends have opened this case and they have consistently argued on a basis which ignores the reality. And the reality is that for perfectly proper, I don't criticise them, on the contrary, perfectly proper commercial reasons, neither E.ON nor British Gas wished to bid for the Bulb assets. E.ON not at all, and British Gas were not prepared to bid for the whole book, which is what the Secretary of State wanted to sell. And this was a commercial decision taken by companies which are highly experienced and which are well resourced in the energy market. They're, of course, two of the so-called Big Six, now the Big Five. The details are in Mr. Jackson's first witness statement, paragraph 86A. Please don't turn it up. Supplementary bundle 1 at S4, pages 140 to 141. So we asked the court to be realistic about this case, and we respectfully criticise the appellants who are not realistic. The reality is that Octopus, which is a more recent entrant to this market, this highly competitive market, were more nimble. They saw an opportunity which other companies were not prepared to take up. And no doubt the appellants regret their decision, but that's the decision they took. And there's a perfectly understandable reason why these appellants were not prepared to bid, and that was the volatility in the energy price market. These were highly volatile circumstances. They're summarised, I do ask your lordships just to look at this, they're summarised, the economic circumstances at the time, in the JEA's amended detailed grounds of resistance. Your lordships just glance at 4 bundle 2 at tab 18, and the relevant passage appears at 493 and 494. Yes, it's paragraph 21, please, at the bottom of C18493, where the administrators, JAs, tell the court the context of the present dispute and the scheme is the exceptional volatility in the energy price market and substantial increases in wholesale energy prices since March 2021. This context is depicted in the following graphic, by which Lazard illustrated the difficult market context and the high level of interventions as at 28th of September in the electricity market. And one can see the volatility. In the 22, prices rose 400% from pre-2021 levels over the depicted period and were very volatile. It was in that context that Bulb failed, and at 23, the exceptional market volatility and uncertainty also explains the lack of appetite from other supply companies and other potential investors to invest in Bulb's business from mid-2021 and during the course of the marketing process in 2022.
Just a factual point, I'm not making a particular point. What was the date of the invasion of Ukraine?
That was earlier, that was
February.
24th of February
24th of February 2022. Yeah. So it was the consequence of, in particular, the invasion of Ukraine. But my point is that it's not surprising in such a context of volatility that, as was the case, E.ON and British Gas were not prepared to bid for the whole of Bulb. But it's also relevant because it explains the pressure which the administrators were under to do a deal with the only show in town, that's Octopus, in the public interest on the best terms that could be negotiated. And there were tough negotiations. And there were no easy answers for the administrators as to how to protect the supply of energy to Bulb customers in these very difficult, indeed exceptional circumstances. And I do respectfully submit that if these appellants had sought permission to bring a judicial review, and they'd said, as they should have done, we withdrew, we didn't want to bid for our own commercial reasons, but we want to raise all these complaints about breach of subsidy principles, it's highly likely that they would have been refused permission at the first hearing. The court would not have been prepared to entertain that type of abstract, hypothetical complaint. And indeed, under the TCA, this question of standing is recognised, the importance of it. If your lordships would please go back to Article 372 of the TCA, we're in Volume 8, tab 93. At page 3697, Article 372, Courts and Tribunals, and your lordships remember, each party should ensure, in accordance with its general and constitutional laws and procedures, that its courts or tribunals are competent to, and then D at the bottom, D, hear claims from interested parties, and in my submission that means persons other than the United Kingdom and the EU, because this is an agreement between the United Kingdom and the EU. Hear claims from interested parties in respect of subsidies that are subject to this chapter, where an interested party has standing to bring a claim in respect of a subsidy under that party's law. So again, the TCA allows for the national law to decide on these matters, and I say to the appellants that on the true facts, as found by the Divisional Court, that this claim should have been dismissed from the outset.
Is that necessarily right? If you're a participant in a market and a competitor is given a massive commercial advantage as constituting a state subsidy, even if the particular advantage is not one for which you would have wished to bid yourself, could you not complain of the fact that a competitor has been given a massive advantage? You would be an interested
my
party.
submission, my lord, not on the facts of this case,
I see, okay.
which are facts which include the finding that the appellants knew perfectly well that state subsidy was available, and they chose, for reasons of their own, not to engage and not to bid for their own commercial reasons. At the very least, it undermines fundamentally the complaint that they've been making in these proceedings, and it would also go, although we're not addressing that today, it would also go to relief, because relief is discretionary. All relief is discretionary, even recovery relief, because Article 373 says that relief by way of recovery may be granted. May. No obligation. So I draw your lordship's attention to that point as well. In my respectful submission, undermines the whole basis upon which this case has been brought. Finally, on remedies, I indicated in my intervention yesterday that I had discussed with my friends Mr. Beale, Mr. Patel and Mr. Peretz their note on remedies, and there is agreement at the bar, subject of course to any questions your lordships may have, that it would not be sensible to spend time at this hearing debating these questions of relief, which of course arise only if the claim succeeds, and the nature of the relief will inevitably, in those circumstances,
Well, the court never thought that the question of relief would be on the agenda for this hearing, save insofar as it was relevant to the question of the
yes, which your lordships have debated with my friend Mr. Hickman. I mention that because their note, and I don't complain about this, their note does go into some detail about what they say they would be seeking and they say they would be entitled to. And I simply respectfully wish to reserve our position on all of that and not engage with it unless and until it becomes necessary to do so. Yes, I'm very grateful to Mr. Bordell, because your lordship asked me for the references to the recent Supreme Court cases that have referred to the Cape Brandy Hang Seng Bank principle. There are two. There's the King on the application of PACCR against the CAT, and the reference is 2023 UKSC 28 at paragraph 252. And the second case is News Corporation and HMRC, which is 2023 UKSC 7, and in particular paragraphs 59 and 121 to 122.
Thank you.
If your lordship want copies of those judgments, we would be very happy to send them through.
Well, I think simply for good order, it sounds as though that they are the most recent and authoritative, and if we were going to refer to this principle, it would be useful to refer to them rather than to the earlier cases.
Yes, these are references to the principle, recognising that the principle exists.
Yeah.
And,
no. The only important thing is just to make sure we've seen them. So why not send them to us?
Very well, we will do so. Lords, unless I can seek to assist further, that's within my time. What I wanted to say.
No, thank you very much, Lord Bannock.
Thank you.
Yes, Mr. Beale.
My lord, I don't know if now's a convenient moment for the transcriber break, or if the transcriber
Would
break.
the transcriber like a break?
I think for a few minutes. But
Yes, of course. We'll have 5 minutes.
Court rise and table.
It's not Lord Carlisle, it's Lord Hodge in the Carlisle case.
Okay. There was a Mrs. something.
Rajavi, is that?
Yeah.
R-A-J-A-V-I. That was in the Lord Carlisle case. Yeah, it may, of course.
Yeah.
Also, it's good that you went to the draft. Still going fast.
Wow. Okay. It's an A1 one. Yeah. Got some registration decisions, so there's registration for subsidy scheme. Decisions role. It's quite interesting to me. There's a just trial. So you're for Ofgem? Yeah. So they were all these sort of shelf companies, fictional companies, which started to get registration. And then, I mean, they would in the future, once they got registration, they'd get investments and they'd start building stuff. And they've done nothing. They'd spent between 33 of these companies, they spent £5 grand. Yeah. And they're claiming £6 million. And it's a claim on liability and a trial on liability. It's not, there's not much liability in issue because they won the JR. So there has been if they had
that near expectation stuff.
yeah.
Like the opposite way around, so we're approaching it.
Which is all.
So you're saying they didn't have any established goodwill?
So,
Do you mind if I take what do you need?
I just need your files there to note.
Then compensation.
May not come up over any water.
Court rise available.
We can go on a little beyond 4:15 since you've only started at 4:30.
thank you very much. Let's see how we get on. I'm hoping to be
Maybe you won't need it. Not encouraging you.
one lives, hope springs eternal. First matter, please could I pass up the foreshadowed note on the meaning of judicial review? Thank you very much. Thank you to Ms. Patel. This is the note that Lord Tannock, for Octopus at least, has given his imprimatur to.
But Mr. Coppell hasn't.
Mr. Coppell has not, and I understand he will need to have a Whitehall ring round before the government will do so.
So I didn't give my imprimatur to it. I said that I wasn't taking a particular point.
I've overstated. I apologise. Next point, if I may. Findings of facts, all of the ancillary matters, commercial judgment, etc. Please can I simply refer the court to our supplemental skeleton. I don't propose to make any oral submission in reply on any of those points.
On which point, sorry?
The role of the appellate court, the approach to findings of fact, all of that material is covered in our supplemental skeleton. There's an issue there about the role of whether or not this is a commercial exercise, etc. There was a couple of new points have emerged. The standing that was taken by my learned friend Lord Tannock, that isn't a point that's taken in the respondent's notice. Our point, very shortly, is that we clearly had standing. We were people who had participated in the process, and we, in any event, we are key players in a market in which there has been a very substantial subsidy.
I didn't get the impression he was asking us to decide this case on that basis.
Well, one never knows the boundary between what's being asked for and what's being deployed for forensic purposes.
Yeah.
Delay. I have 5 short points. Could I please pass up? You asked before the short adjournment about how various things have been put before the court, and I think you have in Supplemental Bundle 2 part of the transcript. Please could I pass up another part of the transcript where we thought that the Divisional Court were asking me about the impact on relief, or my position on relief.
Thank you.
And at page 188 of this transcript, 7 or so lines up from the bottom, I was giving a general overview of the roadmap, as I have done with your lordships. The 6th point is relief, so I'm making reasonable progress, etc. I was then informed by Lord Justice Singh, speaking for myself, and I've read the skeletons, if that's the only thing you don't have time to cover, then we'll find some other way in which that can be addressed. I said I was grateful. Short point to make on relief is Malone and Friends' case collectively is that sky will fall in if you give any relief. Our point is that there's a sensible workaround that can be adopted which will give effect to it, and if the Secretary of State's submission is to be accepted, it would mean that he's free to make an unlawful decision with absolutely no consequences, which is unattractive. So that was the first time in which Lord Justice Singh indicated that relief was not going to be top of his Lordship's agenda, and then you've got the transcript in Supplemental Bundle 2, where he indicates, having discussed it with Mr. Justice Foxton, the court didn't need to hear submissions on relief.
Yes, I think the point, and I say there's no spirit of criticism, but just so it may well not turn out to be material in the end at all. But so far, it's not been suggested that you said on the issue of delay, as a fallback position, well, if you really think we delayed too much to get a quashing order, don't refuse permission. Grant permission, and if we can't persuade you otherwise, refuse that form of relief. I don't see that anywhere we've been shown so far.
It didn't emerge in that way, that's
No,
fair.
fair
It
enough.
didn't emerge in that way because I'd been trying to make the submission that don't worry too much about relief because we will find a way to make that work. And that was echoed, if I can take you to this please, at Court Bundle C, tab 23, page 665, paragraph 66. 3 lines up from the bottom, we said there would be no need to unwind the ETS if another alternative solution can be found. So we were recognising that we may actually not need to have a quashing order. We were suggesting a suspension.
So that's supplementary bundle 2.
No, it's Core Bundle, tab 23, page 665. It's our skeleton for the Divisional Court hearing, paragraph 66. I mean, the point I was keen to make to the Divisional Court, if I can put it this way without undue colloquiality, is I was keen to ensure that we weren't frightening the horses against the substantive points that we were making by a concern that the world would fall in if the court adopted a form of relief which caused everything to have to be unwound. So I was keen to find a workaround, practical workaround, and that's essentially what had been offered both orally and in our skeleton. But my Lord's absolutely right. Did I invite partial grant of permission on the basis of specific forms of relief? No. And the reason I didn't do that was because we had a shopping list of relief. And as your Lordship rightly pointed out at the bar, one's clients want the best. If they can't get the best, they have the fallback.
But it's just to understand how things went. Yeah.
In terms of grounds of appeal, it was also suggested by my learned friend Mr. Hickman that somehow the grounds weren't calibrated to deal with this. In fact, if your Lordships would be kind enough to turn to Core Bundle tab 3, that's Core Bundle 1 tab 3, page 35. Ground 1 says in terms, the Divisional Court erred in law or fact in failing to recognise that we were entitled as of right to apply by way of judicial review for a recovery order. So we were calibrating that particular ground specifically by reference to the recovery order, despite the relevant limitation periods prescribed by the TCA not having expired and finding that claims were not brought promptly. So we were raising a TCA claim, but also engaging with the allegation that the claims weren't brought promptly in the context of specifically a judicial review for a recovery order. That's the second point. Third point is it was suggested that somehow skeleton arguments settled for the insolvency proceedings by other counsel, then instructed by Scottish Power, gave us everything we needed to know to plead the case. With respect, that's wrong. Please could I invite you to take out Supplemental Bundle 1, tab 15, page 391. Just one quick paragraph to look at, paragraph 72. Please could I invite the court to cast an eye over 72.
Sorry, I didn't hear what you just said.
Please would you read paragraph 72, page 391.
The whole paragraph. Yep.
Yes. each of those points is hedged with a considerable degree of conditionality. That conditionality would be inappropriate for a pleading, in my respectful submission. Next point, fourth point out of 5. It was unclear whether or not Mr. Hickman's submission was that somehow the United Kingdom had not put in place a form of recovery order for the transitional period until the implementation of the Subsidy Control Act. If that were the case, of course, that would be landing Mr. Coppell's client in a difficulty because it would lead to a failure to have complied with an international obligation to bring in a recovery order. Fifth point is to note that where my learned friend referred to CJU case law dealing with recovery and the exceptional circumstances in which occasionally recovery will not be ordered, that case law has been addressed in Ms. Patel's note on relief at paragraph 11.6. That is delay. Please may I move on to standard of review, unless the court would less like me to address anything else. I'm being reminded that some of our submissions under the TCA on delay simply haven't been addressed.
I just didn't hear what you said.
Article 3695,
Yes.
I'm reminded by Mr. Peretz, has simply not been addressed. If it hasn't been addressed, it hasn't been addressed. So, can I please move on to standard of review? Submissions on Lipton have been deployed. We don't, as I indicated, haven't had the benefit of advance notice of this argument in the form of a supplemental skeleton. Lipton's been out since July. Quite a lot of the points that have been raised have centred on the 5 authorities that are now in the supplemental skeleton. There we are, I can deal with it. 7 points, please, on Lipton. Firstly, it was common ground below that Section 29 implemented the TCA and that the terms of its application were set out in the Heathrow Court of Appeal judgment. That's judgment paragraph 206 and judgment paragraph 229. Second point, the Secretary of State has not raised the point in a respondent's notice or in a supplemental skeleton, and nor has he applied to withdraw the concession of the common ground below. In particular, it hasn't been suggested that the judgment of this court in Heathrow was wrongly decided. Third point is that the observations in Lipton were in fact obiter. And the fourth point is that the Supreme Court did not address the reasoning in Heathrow as applied to the facts in Heathrow at all. And that has some significance, my lord, because Heathrow was dealing with substantive elements of the TCA regime, namely the abolition of cross-border customs duties. And that was a material part of the international obligations assumed by the UK. And in Heathrow, the conclusions about the application of TCA via Section 29 were clearly part of the ratio of the case. And we respectfully suggest that Heathrow, as the Divisional Court did, should be followed by this court unless it's considered to be clearly wrong, which we say it isn't. The next point is that, in fact, the parliamentary intention to implement those aspects of the TCA which were necessary to comply with international obligations was made clear in the explanatory notes to the 2020 Act, and we have a copy of those somewhere in court. I'm afraid we have the entirety of the explanatory notes in court.
Well, I always thought we didn't have enough paper in this case.
It's perhaps more paper than I would have wished for, but if I can pass up, I'm sorry. Trouble the court associate again. Apologise for the trees that have been killed in this process. I'm not going to talk about proportionality in the context of the length of this photocopy, because it's only one page I want to go to for 2 paragraphs. It's page 31, please. Where the explanatory notes say, in paragraph 263, this section provides that domestic law is to have effect with the modifications that are required for the implementation of the TCA, It only applies to provisions of the agreements which are not implemented by another mechanism and is designed to ensure that all aspects of the agreements are implemented to the extent necessary to comply with international obligations. Now, in my respectful submission, what that shows is, if one reads the international obligation imposed by the TCA and it imposes an obligation of outcome, then the effect of Section 29, following Lord Justice Green's analysis in Heathrow, is to give effect to it. And we then see in paragraph 264 that it provides for existing domestic law to be read with such modifications. That isn't our case, because we have no existing domestic law dealing with subsidy control post-Brexit. And we then see, paragraph 265, that subsection 2 is intended to limit the use of the glossing mechanism in subsection 1 so that any other equivalent or other provision in or under this Act or under any other Act used for the purpose of implementing the agreements has precedence. That feeds into a point my learned friend Lord Panic made, that somehow the SCA is the natural successor to Section 29 and its implementation of the TCA, and that is obviously true. But Section 29 was what I've called the sticking plaster that was put in place to give effect to a transitional subsidy control regime, and it was clearly the parliamentary intention that international obligations be complied with in that transitional period. And if the mechanism they used to do that was the mechanism of incorporation through the broad terms of Section 29, which were adopted. So, sixth point is that Lipton was geared towards a concern about a potential incorporation of what might be described as aspirational parts of the treaty in circumstances where if they didn't necessarily connote a particular outcome, they were aspirational only, they might be perceived not to give rise to hard-edged obligations. It's not the same with respect when one's dealing with a prohibition on restructuring subsidies, or my Lord Justice Dingemans' example of a prohibition of unlimited guarantee. Those are very clear prohibitions, easy to understand, and have to be given effect to in the domestic order. Those are the points I wish to make on Lipton. The reality is Section 29 could have been drafted differently, but wasn't. Now, the logical consequence with respect to the Secretary of State's submission is that, since his suggestion is simply that the TCA imposes public law principles which have to be taken into account rather than followed, every time that the TCA, as a matter of construction, imposes an actual obligation which has to be met, then the UK is in breach of its international law obligation, because it means that it's watered down its commitment to the outcome to be achieved.
You're going to deal with Lord Panic's slightly more
nuanced point. Yes.
Yes.
The point about the 2022 Act, and I'll come on to it now, is the first and most obvious point is it's not retrospective in effect. And the fact that you have different drafting over different periods is simply a parliamentary choice. Parliament could have chosen to say, you, the decision maker, simply have to have regard to principles, but that isn't what they chose to do. They chose to say, through Section 29, that the provisions of the treaty, that to the extent it was necessary to comply with the international obligations imposed by the treaty, that obligation would be transposed effectively into domestic law. Secondly,
sorry to rise, Miller, just so that there isn't any confusion going forward. It wasn't my submission that the public law principle that I relied upon was simply one of having to take into account the subsidy control principles. I said very clearly the principle was, as in Article 366, the Secretary of State must respect those principles.
Well, Mr. Beale has limited time. We can check.
You can check.
Secondly, if one actually looks at the SCA itself, the obligation that is put in place by Section 12 of the 2022 Act, which is the Authorities Bundle, tab 94, page 3710, is that a public authority must not give a subsidy unless it is of the view that the subsidy is consistent with those principles. As a practical matter here, the Secretary of State took the view that he should not be granting a subsidy unless the subsidy was consistent with the Subsidy Control Act, with the subsidy principles set out in the TCA. So there is no difference with respect between the obligation that is imposed upon the decision maker. The issue is, what is the mechanism by which that is reviewed? And I can see why not for today, but in due course there may be an argument as to whether there's a different standard to be imposed. But our submission, for what it's worth, would be because the subsidy cannot be given unless the person who is granting the subsidy is of the view that the subsidy is consistent with those principles. Whether or not the subsidy is consistent with those principles can therefore be reviewed as part of an assessment of whether the decision is a lawful. And in particular, where one has the proportionality standard, and I'll come on to develop this in a moment, it's clear that if the view is taken that the subsidy is consistent with proportionality, but the court takes the view that it's not, then subject to the issue of weight, that would simply build in the proportionality standard, which is a standard recognised in our domestic law for the review. So I do not accept...
When you say proportionality is recognised in our domestic law, is that right?
It is to the extent that the statute recognises
Oh, I see.
that proportionality would be applied. It's not a freestanding ground of judicial review at this stage.
No.
And what we don't have is the Subsidy Control Act Schedule 1 Statement of Principles, where they essentially enumerate the various principles that are found in the TCA in Article 366. So you weren't burdened with that one piece of paper.
Like the data protection principles.
Yes, exactly. But in my respect...
outside a human rights context, I'm not saying you're wrong, I just can't immediately think of any examples where a proportionality standard has been incorporated into domestic legislation explicitly.
The Communications Act 2003 in Section 2...
My lord's obviously familiar with it and I'm not.
The Electricity Act 1989 has an obligation on the regulator and the Secretary of State to have regard to the principle of good decision-making.
Sentencing Council guidelines, there's a lot about proportionality, and under the Sentencing Act you have to have regard to it.
There are a series of statutory requirements.
I suppose really what I was asking is not so much what I was asking, whether there are such provisions, but whether when there are such provisions, the important point is whether the court has regarded them as matters which are primarily matters for the decision maker and only reviewable. We know in the human rights context that is not the approach taken, but that may be said to be for reasons peculiar to the Convention of the Human Rights Act.
My respectful submission on that is the reason why this court has a decision-making role on proportionality under the Human Rights Act is to give effect to Section 6 of the Human Rights Act, where it's unlawful for a public authority to act in contravention of a convention.
I dare say, but that particular structure, I'm not aware of having been adopted anywhere else. If I found in a statute something saying the decision maker must form the view that such and such an act on their part is proportionate, I might well be inclined to say that in a non-human rights context, that decision on proportionality was only reviewed on ordinary rationality principles.
But the hook that we're relying on in Section 29 is even stronger than Section 6 of the Human Rights Act, because Section 6 of the Human Rights Act lets people off as a public authority in circumstances where there is primary legislation and the relevant authority has no choice but to act in the way it does because of primary legislation. So there's a get-out clause in Section 6, which doesn't exist in Section 29. And Section 29 says in terms, you will give effect effectively in domestic law to the obligations found in the TCA. One of those obligations is that subsidies granted by the state have to be proportionate. There's also an additional, I'm told that the Procurement Act 2023 has proportionality obligations, but I'm afraid that's beyond my direct knowledge. There's the further point that, of course, the Subsidy Control Act has brought in the concept of an independent authority because of the advisory role given to the Competition and Markets Authority. So it's a different structure in the Act. And so to deal with the Hang Sen point, there is no ambiguity in Section 29. And in any event, it's quite clear that the 2022 Act represents a different structural implementation of the TCA because they've adopted the position that there should be an independent authority, albeit with a a non-binding function. But they've recognised, therefore, that it's a different manner of implementation from the one before. So whatever Hang Seng may or may not say in the context of ambiguous statutes being clarified by later ones, this isn't. There have been legislative policy choices by Parliament between the two particular measures. In terms of standard of review generally, there was an issue raised by reference to the Monopolies and Mergers Commission case, South Yorkshire. I don't, I think, have time to go to it specifically, but can I simply give you this reference? It's Bundle of Authorities 1, tab 4, page 69, letter H. And the court was recognising that there were two separate questions. Firstly, you had the meaning, what is the legal meaning of the phrase substantial part of the UK? And that was required because it established the jurisdiction of the MMC to engage under the Fair Trading Act with the merger provisions. And the court found that when it's a question of a hardwired legal test, and that's the red sideline in the report, Lord Mustell said, well, of course, when it's a question of jurisdiction, I would agree that it's a hardwired legal test, and you either have the jurisdiction or you don't. And as long as they've directed themselves correctly as the meaning of what substantial means, that passes the legal test. There's no error of law as long as they've directed themselves properly as to how one would go about defining substantial. And the question there was, have they done that? That was the first question, answer they had. There was then a second evaluative phase where they were required to work out whether or not South Yorkshire was substantial, to which the answer is they could have simply asked a Yorkshireman and they would have got a very robust answer. They didn't do that. But they did, on a number of factors, then find that South Yorkshire was substantial enough to fall within the jurisdictional clause. But that was a question of evaluation and judgment, and it was to that secondary stage that Lord Mustell was directing his comments as to giving the decision maker some width on how the clause was to be applied. Now, in contrast, and I've given my lords this reference previously, in the Singh and Commissioner of Police case in the Privy Council, Lady Black, this is Bundle of Authorities 4, tab 42, page 1682, was faced with what she described as an ambitious argument that it didn't matter whether or not the legal interpretation applied was correct or not. It was sufficient if the Commissioner of Police in that case had interpreted it in a reasonable way. Now, this was the ability of a superintendent to sit some exams before he was actually a superintendent, whether he qualified to then be made a superintendent. The answer from the Commissioner was, well, we were entitled to take the reasonable view as to what the law required, and Lady Black, the Privy Council, made it clear that the question of legal interpretation was for the court, and the idea that an error of law could be excused on the grounds it was not an irrational one was described as an unpromising argument. That's paragraphs 25 through to 31. Now here we're in a position where Section 29 was the only show in town for subsidy control for the transitional period, and it's consistent with parliamentary intention that it should be given effect, where to do so otherwise would be to fail to give effect to international obligations that the UK has assumed. And it's somewhat, I don't wish to add more heat than light, but it's somewhat discreditable to try and water down the strength of the obligations that the UK has assumed by suggesting that this court should allow the United Kingdom to have the least intrusive possible form of implementation in circumstances where the parties to that international treaty, as seen from recitals 8 and 9, very clearly thought that they were trying to establish a level playing field. And if, as we suggest, and I'll come on to deal with this next, if the correct approach as a matter of EU law to a decision by a member state to give aid is that you would have a proportionality review along the Lumsden lines, which we say would be the test, then it's no answer to say that the UK should have a lower approach to, for example, proportionality review than Lumsden would suggest on a domestic basis.
Well, I mean, it's quite apparent, isn't it, that Article 3723, if I got the reference right, was quite carefully intended to preserve the domestic court's standards of review.
Yes.
And must therefore have recognised in principle that the standards of review might not be identical.
Well, the standards review would encompass error of law, and they would encompass a proportionality review that if it's phrased in the way it is, equivalently to the way it's phrased in Section 6 of the Human Rights Act, if not stronger, then that would encompass this court determining whether or not a decision is proportionate. That's all part of the existing panoply of rules that were well known before the TCA was even a twinkle in anyone's eye. We had this argument back in the early 2000s when the Human Rights Act had first come in, and a series of cases leading to a case called Mahmood in the immigration field had the Secretary of State saying, well, it's all very well the court saying I haven't acted proportionately, but the proper approach is to say whether or not it was within the reasonable scope of my decision-making powers that I would take the view that it was a proportionate decision. It's for me to decide whether or not it's proportionate, and so long as that's rationally held as a view, you cannot intervene. And I think it was Lord Bingham in Huang gave the death knell to that, and from Huang the rest of the cases have been rolled out to find that it's this court that ultimately is making the final call on whether or not a decision is proportionate. My learned friend's approach to Lumsden was to say, oh, well, the manifestly inappropriate part of that test applies to EU institutions, and it's the EU Commission that's applying state aid. With the greatest respect, the clue is in the name with state aid. Aid is given by the state. It's subject to review by the domestic courts of the member states. True it is that there's a notification process to the EU Commission. So some of the cases that you've seen specifically deal with the issue of what is the test for the EU Commission to be challenged on a state aid decision. But that's a very different set of facts. The ordinary generic challenge in a domestic court like ours, taking place in France or Germany, will apply the Lumsden proportionality standard for a member state that is departing from, prima facie departing from, obligations as a matter of EU law. Those are the passages I took you to. And my learned friend and Lord Panic, Mr. Coppell and Lord Panic relied on the Friends of the Earth decision. Can I simply say that that was a case in which there was an iterative process for publishing the relevant information so that the decision maker could give the relevant information not only over various different types of documents, but also over time. And the relevant test was whether or not the decision maker had reasonably included sufficient information in the overall process in order to discharge the duty of providing sufficient information. Now, that's a very open-textured set of legal obligations, which, in my respectful submission, is very different from the sort of legal obligation we're dealing with in Article 366 and 367. Importantly, page 63 of that report, paragraph 146, the court made the perfectly sensible point that if the obligation were as hard-edged as had been suggested, authorities would simply end up defensively drafting reports that included absolutely everything, and the meaning would be lost. Now, the Sky Blue case, importantly, was about the MEO-CMO principle. The margin of appreciation was accorded to the decision maker in Sky Blue precisely because the issue was whether or not the public authority was acting in the same way as a rational economic operator in the private market would. And it was precisely because the rational economic operator would have a slew of potential commercial responses to a given set of facts that the margin was as wide as it is. Now, there's an important distinction in this case between two different types of subsidy. We have the subsidy that has been granted to Hiveco, which is acknowledged in the SCA to be a subsidy that is a subsidy, i.e. the CMO test does not apply. Why is that? Well, because it's recognised that the hedge, for example, is not available on commercial terms, and that an interest-free loan is not a commercial offering. And so the SCA recognises that the Hiveco portion of the elements of the subsidy don't satisfy the CMO test. Where the SCA relies upon the CMO test is to justify the level of the equity injection from Octopus, which Mr. Jackson in open evidence has said is around the £100 million mark or so. Now, the Secretary of State never assessed that subsidy to Octopus by reference to the subsidy control principles because he took the threshold view that the CMO process had been followed as a result of the discharge of an open, non-discriminatory and competitive sales process. That's SB Supplemental Bundle, tab 44, page 623. And that conclusion necessarily means that the Secretary of State simply hasn't taken into account the subsidy control principles for that portion of the subsidy.
Which portion of the subsidy?
It's the buyer equity injection from Octopus. It's
Octopus's money.
Octopus's money going into the Hive
How is
Co.
that a subsidy?
Because it wasn't determined on the basis of an open, non-competitive, non-distorted.
I'm sorry, I'm missing it. How is it a grant from the government at all?
Because they haven't paid the market value for the equity that they have acquired through the equity injection. They've paid a distressed rate for that equity, and the market price has not been determined through a market process, because in fact the price that's been paid is very simply an assisted price.
That doesn't make Octopus equity injection a subsidy.
My lord, they've paid for the acquisition of shares.
So the question is, are they the beneficiary of the subsidy otherwise given? Isn't that the question?
The basis upon which the Secretary of State formed the view that the equity injection was not a subsidy was precisely because the value paid by Octopus for those shares had been determined through what was said to be an open, non-discriminatory and competitive process. And that produced the figure of roughly £100 million or so. Can I show you, please, in Mr. Lawrence's evidence, it's Supplemental Bundle 1, tab 1, page 42.
Reference, please?
Supplemental Bundle, Volume 1, tab 1, page 42. What did I say? So this was a witness statement filed as part of the claim to go into ESC administration, and one sees at the top of he's dealing with what assets are owned by whom. He's dealt with, at the bottom of page 41, with total liabilities and so on. And then there's a predictive element at the top of page 43, where he says the company's analysis is that the cost of supplying energy to customers through the winter until 31st of March 2022 will incur a total loss on its profit and loss account of 782 million. So the market price for this company, predicted to be by the 31st of March 2022, was deeply negative. So nobody's going to be spending £100 million on a deeply negative company in terms of that, to that extent. So why is £100 million that's been paid not the market price? Well, because it has effectively taken into account the fact that there is no debt and that the hedging exposure has been dealt with, so that cash flow problem has been addressed. So it's been addressed, and therefore the amount of money that is offered is necessarily predicated on the two issues I said were paramount in this case, namely the debt and the working capital needed to provide a proper commercial hedge. Those have been sorted. And so the bid,
what, sorry?
They've been sorted, they've been taken care of. The bid comes in on the very assumption that the subsidy is going to be granted. And so the two things that are forcing the valuation of this company to be deeply negative don't bother Octopus, because it knows it's got the government commitment to be able to offer the figure of 100 million, which isn't reflective of the market price, precisely because it knows the subsidy is going to be given to it. Now, in terms of subsidy control principles more generally, had a proper process been followed here, what would have been ascertained was not the so-called market price of bulb in the M&A process, but the level of government funding which was the minimum needed to secure the sale of bulb. And that would have enabled to adopt my Lord Justice Underhill's, the way it was put in the transcript that was shown to me this morning by Mr. Coppell. It would have enabled two things to be highlighted. One, the existing debt of the company will be dealt with or can be dealt with through government funding, and two, the unhedged exposure can be dealt with through the availability of government funding. And it's not potential availability, it's actual availability. It's getting the commitment from the government that this funding will be available. You tell us, actually, in your own words, how much of it you think you need. And that could have led to different bids by different people.
Sorry, this is a reference to something
It was the transcript referance at...
if it's important to your submission, but tell me what the reference is.
The reference was in the transcript that Mr. Coppell passed up, I think. Maybe he just gave a reference to it. It's page 29 of day 2. So yesterday morning. And you, my lord, said, suppose it had said explicitly, the government had said explicitly, or more explicitly than it did, we recognise there is a problem in these two areas. We're open to suggestions as what support we might give. We're looking to you to propose what sort of support.
Okay.
So what mattered was not the potential availability, but the commitment. And it was the commitment that both Octopus and Tulip received in different forms through different communications. It was that commitment which was never given to us. And with the greatest respect, the counterfactual exercise, who would have done what, who would have bid what, is irrelevant, because once you have a situation in which the key participants in the market, let's just keep it at the 19 companies that did sign the NDAs, just for the sake of convenience, but once those key players in the market are told the government is behind this, government will be delivered, you will get government funding to the extent that we feel we need to give it, using a structure that can be derived from bids. Once that point is out there in the market, then people can legitimately then compete through a bidding process or through some other process to drive down the level of subsidy that needs to be.
Well, these are points, I mean, I'm looking at the time,
Yes.
This is a reply, these are points you made yesterday.
Now, in terms of it was suggested that we were only after splitting the book. Without the government commitment of funding, nobody was going to be able to afford the whole book. So, with the greatest respect, it's unsurprising that market participants were saying, well, we can't bite off more than we can chew, and so we will have to take some of the book. Contrary to paragraphs 247 to 248 of the Divisional Court judgment, as was suggested, this isn't simply an evidentiary matter. This is a key and important matter.
Okay, we've got the point.
In terms of benchmarking, could I simply refer you, please, to Secretary of State skeleton below, which is Core Bundle, Volume 2, Tab 24, page 705, in particular paragraph 118, where the Secretary of State recognised that full comparison of the transaction against previous transactions would not be possible, and the benchmarking analysis was simply a useful cross-check, not the primary means of determining, it was said, the level of the subsidy. It's also been covered in our amended statement of facts and grounds, that's Core Bundle, Tab 9, page 226, and in E.ON Skeleton, Core Bundle, Tab 22, page 631 to 633. There was an authority cited by my learned friend Mr. Coppell, the Voltaire case. Please could I invite the court in due course to read the relevant factual background, paragraphs 5 through to 12.
What will we get? Why do you want to speak?
Because the legislation identified the fund that was available. That legislation was given to airport operators. Airport operators then had an expression of interest process whereby airlines could express interest in applying for part of the funds. And it was on that factual basis, it was found that there wasn't a need for a full bidding process to obtain access to those funds, because each airline was approaching the authority directly to be able to get a tranche of funds that had been identified using a process whereby they would submit operating plans. So bizarrely, that's a situation in which a fair and transparent process was adopted to enable everyone to compete on the same basis for a firm commitment for government funding. National emergency, global emergency, Ukraine. Our short point is it wasn't the Russian invasion of Ukraine that caused Bulb's difficulties. It was already in, had the benefit
This is the point you made.
Yes, a rescue subsidy. It was suggested today that Bulb itself going insolvent might be a national emergency. If one looks at Walker 1, paragraph 18, that's supplemental bundle, tab 2, page 89. There was never any question of energy customers not being protected. Once you had the rescue subsidy and the ETS was in place, nobody was going to physically disconnect any particular customer from the electricity supply. It was then a question of moving from rescue subsidy to restructuring subsidy. And what has changed with the Ukrainian invasion is not the need for the restructuring subsidy, it's the extent of the public funding that may be needed to cover the wholesale hedge. That's what's changed. So it's a difference of degree or extent, not a difference of principle. Turning, if we may, to the concluding observations. And in some ways, I can do no better than read back some observations from Mr. Koppel in the course of his submissions to this court. He said,
I'm not sure at the moment what you're doing. What points are you addressing?
I'm addressing points he made to this.
Oh, I see. Oh, well, in that case, yes. So I wasn't quite sure what exercise you were doing. You're going to give us a commentary on his clues, including observations.
It's a proper reply in the sense I'm drawing to the court's attention the logical consequences of his submission.
Okay, off you go.
Firstly, he said it was a much more iterative process involved here, and he said in terms if Tulip didn't know about the availability of government funding, they were shortly disabused by the Tulip email. Secondly, when pressed on whether or not it was a subsidy auction, bidding competition, subsidy competition, whatever word one wants to use, he said it was a highly complex transaction which had to be structured in a way to get the best value, which was not to be specific or prescriptive about setting out exactly what would be required, and not definitive about the availability of government support. A reasonable judgment had to be exercised in the circumstances. So he was decrying any suggestion that there had been an open bidding process as we would describe it. And then finally, when pressed on Lazard's and its role, he said that they gave further indications of government support where it was felt to be necessary to keep bidders interested. And we respectfully suggest that that is not a way in which the lowest form of subsidy should have been ascertained. It's not going to give the court confidence that this subsidy is no greater than it need be, and it's not a process that is anything other than the way it was described by Mr. Quantock, which is there's no proper process here, they're just trying to get the deal done and playing it by ear. My lords, we do have criticisms of the process, not as a marketing process, but as a means of soliciting the minimum level of subsidy that is necessary to get this transaction across the line. And that's the flaw. It's the schism, as I've called it many times, the schism between responsibility for the subsidy control principles and getting the deal done, whichever way it can be done. My lords, unless I can assist any further, I'm suggested to Mr. Perrott he may want to follow, but he has no time to do so.
No, well, this will have to be something you'll have to fight out with him.
Yes. I simply adopt, of course, the submissions of my learned friend.
That's a very short follow.
Very well. We're grateful to Council for their submissions and to the contribution of all those, the many rows behind, to those submissions. We will, of course, be reserving our decision. Judgments will be circulated in draft to Council in due course. The circulation of those drafts will be severely limited to those who need to see them for the purposes identified in the Council Journal for Wales case, which you're all aware. And if they are circulated more widely or for any other purpose, that may well be a contempt of court. And it's important that those constraints are carefully observed, especially in a case like this where there are very large teams. Thank you all very much.
Thank you, Lord.
Court rise in favour.